Distinguished guests, ladies and gentlemen, my name is Saad Hegazy. I'm the Vice Chair of the Chartered Institute of Arbitrators Qatar branch. Allow me to address you today instead of my colleague Richard Macon, the Honorary Secretary, who had an emergency and he will be late in the morning. It's my pleasure to welcome you all to the first FCIArb Qatar Arbitration Conference. This historic event hosted by the Chartered Institute of Arbitrators Qatar branch brings together over 300 arbitration practitioners, local and international, to network, share knowledge and ideas, and gain new insights into the field of arbitration. As the first of its kind event in Qatar, the conference will cover a range of topics, including the future of arbitration and the use of artificial intelligence, current challenges and updates in the arbitration, and the role of experts in arbitration. We are honored to have the support of the Qatari Judiciary and Chambers of Commerce and international arbitration centers, universities, local and professional associations, and corporate entities from both public and private sector. Their participation reinforces the importance of this event and highlights the significant contribution it will make to the development of arbitration in Qatar. Absolutely, before we proceed with the conference, I would like to extend our sincere gratitude to all our sponsors and partners who have made this event possible. Our platinum sponsor, Omanian Partners, have been instrumental in bringing together the best practices from around the world and ensuring that this conference is a success. Our strategic partner, Qatar International Court, QIC-DRC. I would like also to thank our gold sponsors, DMD and Multiplex, our silver sponsors, Resolve International, Resolution Chambers, Mason, Al-Haj Al-Marri, and finally, Advocate Fatma Al-Saidi. Our bronze sponsors, KO and Reddy Smith, for their support in making this event reality. We are grateful for their commitment and promoting arbitration in Qatar and region, especially the local firms like Ms. Fatima. Our partners, Qatar International Arbitration Center, Saudi Commercial Arbitration Center, the Cairo Regional Center for International Commercial Arbitration, Kuwait Commercial Arbitration Center, and African Arbitration Academy. Also the colleges of law at Qatar University, Lusail University, and Hamad bin Khalifa University. The local associations, Qatar Lawyers Associations, Qatar Society of Engineers, AACE Qatar, and ICC Qatar, and also international organizations like the ICC International and the Academy of the Experts, without, of course, forgetting the equal representation in arbitration pledge. These organizations have contributed to the development of arbitration in the region, and we thank them for their continued support. I would like also to acknowledge the contribution of our media and knowledge partner, LexisNexis, Josimendi, and Legal Plus for their support in spreading the word and ensuring that this conference is a resounding success. And at last, while entering a new era, the metaverse partner, idfa.com. Finally, I would like to thank all our supporting partners and organizations without whose support and collaboration this conference would not have been possible. We are grateful for your support and look forward to working with you in the future. So certainly before we begin the conference, I would like to take a moment to reflect on the progress and achievement that the Chartered Institute of Arbitrators Qatar branch has made over the last 12 months. During the time, we have worked tirelessly to promote arbitration in Qatar and the region. Our efforts have included offering courses in Arabic for the first time, organizing more than 6 successful events, conducting discussions with stakeholders, and collaborating with regional branches. We are proud to announce that we will sign also today a 2 memorandum of understandings with the Qatar Lawyer Association and Qatar Engineers Society, which will further strengthen the partnership and promote the development of arbitration in Qatar. Additionally, I'm pleased to announce the results of the branch committee elections that we have 3 new members joining our team, Mr. Khalid Al-Garhi, Stephen Robertson, and Dr. Ghada Darwish, which have been elected to the committee, and we look forward to working with them to continue our mission of promoting arbitration in Qatar. So congratulations. So now it's my pleasure to introduce the chair of the Chartered Institute of Arbitrators Qatar branch, Dr. Nasser Al-Azba. Dr. Nasser, vision and hard work have been integral to the development and the growth of arbitration in Qatar, and we are honored to have him here to officially open the historic conference. And before you joining me to give him a warm welcome, I would like to read a little bit about Dr. Nasser. Dr. Nasser is a lawyer and the chairman of the Chartered Institute of Arbitrators in Qatar branch. and expert in international investment law in MENA region and full-time professor of international investment law in Qatar University. He specializes in drafting and review of major construction contracts and practices in the field of international investment law and international trades and dispute resolution, having recently been chosen for the World Trade Organization roster as of a panelist, WTO. He is regularly involved in cases arising from international construction law, state and private commercial investment agreements, and bilateral and multilateral international treaties, negotiations, and agreements. Dr. Nasser also specialized in public-private partnership contracts and partnership and technology transfer contracts and the review of oil and gas agreements. He is renowned for his skills as a commercial negotiator, mediator, and arbitrator and investment arbitration and alternative dispute resolutions. Academic awards and achievements: he had a PhD in International Investment Arbitration from University of Manchester and GDL International Negotiation and Mediation and Dispute Settlement of Harvard University, and Master in International Oil and Gas from the Graduate Institute of International Development Studies from Geneva, and LLB from Qatar University Faculty of Law. So please join me giving him a warm welcoming to open the conference.
السلام عليكم ورحمة الله وبركاته. السيدات والسادة، أعضاء المعهد الملكي الكرام وضيوفنا الكرام، السلام عليكم ورحمة الله وبركاته. أرحب بكم جميعا في مؤتمر المعهد الملكي للمحكمين. يعتبر المعهد الملكي للمحكمين هو الوجهة الدولية الموثوقة في التعليم والتدريب والتطوير لوسائل حل المنازعات البديلة على مستوى العالم، حيث يحمل عضويته ما يربو على 17,000 شخص، وهو ما حملنا مسؤولية كبيرة في أن تكون مخرجات هذا المؤتمر تتناسب مع المكانة الدولية التي يحظى بها المعهد والذي شرفت برئاسته في قطر العام الماضي. ويعتبر التحكيم هو أساس وسائل حل المنازعات البديلة وفقاً لما يتمتع به من مزايا، أهمها مساعدة القضاء الوطني في حل النزاعات التجارية، والأمر الآخر هو إلزامية تنفيذه دولياً طبقاً لاتفاقية نيويورك 1958. سنتناول في هذا المؤتمر إن شاء الله مجموعة من المحاور التي ستلقي الضوء على آخر المستجدات في التحكيم، يلقيها مجموعة من الخبراء الدوليين في مجال التحكيم والطرق البديلة لتسوية المنازعات، حيث سيتناول المحور الأول مستقبل التحكيم في ظل الثورة المعلوماتية الخاصة بالذكاء الاصطناعي. أما المحور الثاني فيتعلق بالتحديات المعاصرة للتحكيم، وفي المحور الثالث سنلقي الضوء على التحكيم الدولي وتحديثاته، وفي المحور الرابع والأخير سيتم النقاش حول دور الخبراء في إجراءات التحكيم. الفكرة الرئيسية من هذا التجمع هو جمع أصحاب المصلحة مع الخبراء والمحامين، والذي حدث لأول مرة في دولة قطر، وسيتخلل المؤتمر استراحة لشرب القهوة وغداء عمل، والذي سيتيح الفرصة للتعارف. ونثمن مشاركتكم جميعا في هذا المؤتمر، والذي يعزو نجاحه إلى حضوركم وتفاعلكم، فشكرا لكم. السلام عليكم ورحمة الله وبركاته.
Thank you so much, Dr. Nasser. We honored also to have 2 videos from our international team for the Ciarb. So please, I would like to play a video for you, a welcoming video from Catherine Dixon, the CEO of the Chartered Institute of Arbitrators.
Thank you for inviting me to speak at Ciarb's Qatar branch AGM. I'm sorry I cannot be with you in person. I'd like to thank Ciarb's branch committee, who worked so hard for Ciarb in Qatar and for organising this AGM. I'd also like to thank you for attending today and for your support of Ciarb. My name is Catherine Dixon, and I'm the Director General of the Chartered Institute of Arbitrators, Ciarb. I'm delighted to see how well arbitration and ADR is growing globally, and in particular in Qatar and the Middle East, where Ciarb's membership is also growing. Our world is facing significant challenges, climate change, cost of living concerns, conflict and unrest, and I'm confident that ADR can play a crucial role in supporting sustainability in the future. And it's clear an exciting and fascinating time for arbitration and mediation in Qatar, and I feel honoured to be part of it. Many of you are familiar with Ciarb, indeed many of you are members, but it would be remiss of me if I didn't take this opportunity to tell you a little bit about Ciarb and how the organisation is growing. Ciarb is a global membership and professional body dedicated to effective dispute resolution. Our global membership is growing to over 18,000 members in over 150 jurisdictions around the world. We also have 43 branches globally, which are run by our members for our members. Ciarb's aims are to globally promote the constructive resolution of disputes, be a global and inclusive thought leader, and to develop and support an inclusive global community of diverse dispute resolvers. Our vision is a world where disputes are resolved promptly, effectively and creatively, and our mission sets out our commitment supporting equality, diversity and inclusion, enabling the best to join us and the ADR profession, irrespective of their background, supporting the rule of law and enabling access to justice globally. As a Royal Chartered body and registered charity in England, we are also dedicated to driving and supporting professional and ethical standards. Ciarb's post-nominals, once you have completed our training and become a member, are recognised globally, including by many arbitral institutions and arbitration and mediation panels. We provide professional practice guidance and have, by way of example, recently launched a technology in arbitration professional guideline. We have expert groups on ADR disciplines and technology and sustainability. We are also an active participant at UCITS Trial Working Group 2 and 3 and use our observer status to represent our members globally. Ciarb also has an active and dedicated young members group, and I'm sure practitioners in the early stages of their career will benefit from networking with other younger professionals around the world. We provide career support, ongoing learning, events, training, mentoring and networking within a worldwide ADR community. There is so much opportunity for ADR and ADR practitioners in Qatar. Once again, I'd like to thank the branch committee for arranging today's event, and I'd also like to thank you for attending. I do hope you enjoy this AGM, and if you haven't joined us already, please do and become part of Ciarb's global community of diverse dispute resolvers. Thank you.
Thanks for Catherine. So the last message is from Professor Dr. Mohammed Abdul Wahab. He is the regional trustee of the FCIArb and founding partner and the head of international arbitration, construction and energy groups at Zulfiqar and Partners.
Dear colleagues and friends, ladies and gentlemen, it is a privilege to appear before you today, virtually I'm afraid, following the very kind invitation by the Qatari branch of the FCIArb to give a welcome speech, a very brief one, I would say, to the first Chartered Institute of Arbitrators event in Qatar by the Qatari branch in Doha at the Four Seasons on the 10th of May 2023. So when you will be hearing this, it will be the day of the event. I would like to congratulate the Qatari branch on organizing this first international conference of the branch on topical arbitration issues. Special congrats to Dr. Nasser Al-Adwa, who is the chairman of the branch, and all members of the committee of the FCIArb Qatari branch. I'm also glad that Catherine Dixon, the Director General of the Chartered Institute of Arbitrators, is appearing with you today to represent the Institute. I'm also delighted to note that the topics chosen for the conference center around 4 topical issues in relation to the future of arbitration and the use of artificial intelligence, current challenges and prospects and updates in the field of international arbitration, and the OIC, which is the Organization for Islamic Cooperation, and the Arab Investment Treaty in relation to investment arbitration provisions, as well as UNCITRAL updates in the field, as well as the fourth theme relating to the role of experts in international arbitration. The fact that I'm thrilled that the branch has organized the event in relation to those four streams and four main topics is that each and every topic of those is close to my heart. Having spoken and published on each and every aspect of those topics, I'm delighted that you will be hearing seminal and brilliant contributions by people, prominent practitioners, academics from across the globe. I do note that I am unable to be physically with you today because I am in another location, in a different jurisdiction, relating to another professional commitment. One thing that I have failed to do up till today is to be at two different places at the same time, physically. Hopefully, with the advance of technology, this could be a possibility, though I doubt in my lifetime this is going to happen. Be that as it may, I wish you a very successful event, and I hope that that landmark event will result in some recommendations and a compendium of the proceedings of this conference to distill some of the findings and views in relation to each stream of the four areas that that conference is covering. I wish you a very successful conference, and I have no doubt that you will hear excellent contributions, points of views by each and every speaker on every panel. I do convey my sincere thanks once again, and I do hope to be able to visit Doha very soon on another event, and I'm truly proud of what the Qatari branch is doing and for the excellent work being done by the whole committee. Dr. Nasser, Mr. Saad Hegazy, and all the other prominent members of the Qatari branch committee. My sincere thanks, my best wishes, and I wish you a very successful event. Wishing you all the very best, and goodbye until we meet in person next time. Thank you all very much.
Thanks to Dr. Muhammad, and moving forward, I would like to invite my colleagues at the first panel to join me, Antonia, Sarah, and Hilary. So welcome everyone to our panel discussion on the future of arbitration and the use of artificial intelligence. So I'm sorry that you have to see a lot of me today, but the first one I was covering for Richard. So I would like to thank you all for coming for our first conference, where we are celebrating actually the 5th anniversary of our branch. So today we will be exploring the existing possibilities and the challenges that arise when cutting-edge technology meets traditional dispute resolution. With the advent of the artificial intelligence in the field of arbitration is rapidly evolving, and it's essential to stay up to date with the latest trends and development. So as the moderator, I'm excited to be joined by a shining group of experts who will be sharing their insights and experience on this topic. I know that many people will envy me today, as I have an outstanding, shining panel consisting of some of the brightest female arbitration practitioners and professors. But when it comes to speaking about the future, I prefer to count on ladies. So ladies and gentlemen, let me start by introducing quickly our panel and the topic of our discussion today. So Antonia, Birt. Antonia is a partner, Reed Smith, LLB in Dubai. acts as a counsel and advocate in the commercial and construction disputes, having been based in the Middle East for the last 13 years. Antonia also acts as an arbitrator, having previously sat as in ICC, DIFC, LCIA, and DIAC arbitrations. Since 2019, Antonia teaches the international arbitration to LLM students at the Pantheon Assès University Paris and in UAE. Antonia is a member of the IPA Commercial Arbitration Case Law Subcommittee, responsible for the UAE, having previously co-authored the original and updated editions of the IPA Guides on the Arbitration UAE Law Chapter. Welcome, Antonia. Sarah Malik. Sarah is in the advisory board of Dubai International Arbitration Center. She is the founder of SOL International and the International Dispute Council. Sarah Malik is an award-winning lawyer who achieved a Litigator of the Year 2022 at the first GCC Women in Law Award and received honorable mention as the Law Firm Leader of the Year. In March 2022, SOL was named by Legal 500 EMEA as a firm to watch in dispute resolution, arbitration, and international litigation. And in 2023, Sarah has been listed as a leading practitioner in the arbitration power list Middle East Legal 500 EMEA. Welcome, Sarah. Last but not least, Hilary Bell. Hilary is an assistant professor at Hamad bin Khalifa University College of Law. She teaches construction and infrastructure development law, dispute resolution, and legal skills courses. Hilary is a solicitor and a notary public, a fellow of the Chartered Institute of Arbitrators. Before joining HBKU Law, she was a construction dispute lawyer in Qatar. Welcome, Hilary. So let me start by laying the root down to the audience by explaining the definitions, what we will be discussing today. So I asked our Metaverse official partner, IDFA, to create a quick video to explain a few definitions. So if we can play the video, I would appreciate it. Can we play the video? I think you are playing the wrong video. I'm looking for the Metaverse video.
Welcome. We heard recently a lot of many terms related to the digital future. Blockchain, NFT, smart contract. But what are these terms that invaded our world? Blockchain is a technology known with the emergence of cryptocurrencies, and it is a database that is shared between more than one computer. Let me explain to you. Let's assume that you are going to send money, Bitcoin for example. This transaction passes on a blockchain. This process is verified on more than one side before approving the process, as if it were a bank employee. This process is recorded in blocks and placed on the network, with the transactions that were recorded in the past, and that will be recorded in the future. And this network records on all computers in the world that there is a transaction that occurred somewhere. Blockchain distributes data, but it does not copy it, which means that this data has only one owner. Not like Facebook posts, anyone can copy it. Therefore, blockchain is considered the most transparent record in history because it has all transactions that occurred on it. Meaning, if you purchase an NFT, details, time and value of the transaction will appear to all computers in the world. Don't worry, blockchain is very secure and impossible to hack. It's estimated that the force needed to penetrate it is 10 to 100 times greater than Google. And this is Google, the largest search engine in the world, which means that the penetration process is impossible. NFT, or non-fungible tokens. But what does this term mean? It means that it is a digital asset or property. If you own it, you become its sole owner in the world. And it is registered with an identification number on the blockchain that proves your ownership of it. If we use a famous painting such as Mona Lisa as an example, there are many copies of it in the world. but only one copy is the original in a Louvre museum in France. If we assume this painting is accompanied by a certificate from the owner, with an identification number that proves this painting is the original, if we are safe to falsify it. But what are its uses? NFT provides the idea of trading and the possibility of resale, which helps in making money. It can be linked to a physical asset or digital or even a living being. Many groups allow communication between the holders of their assets in the formation of a club or community of their own, which enables people to communicate with the stars and celebrities who hold these assets without any barriers. Smart contract. Smart contract is a self-executing contract in which the terms of the agreement between the seller and the buyer are written directly, and the agreements contained in it are recorded on the blockchain. It is worth noting that smart contracts allow the implementation of reliable transactions and agreements between disparate and anonymous parties, without the need for a control system or a central authority. It is used in many cases, most notably, government voting system, financial services, healthcare.
So thank you so much. Now I'll leave it to the panel to explain more. And Antonia, would you like to start?
Thank you. Well, thank you very much for having me, first of all. I'm honored to be here today. Thank you for Saad for organizing this really fantastic event. Move past the definitions. We will talk briefly about arbitration then and now. I'm not going to go back as far as the good old days prior to any technology in arbitration. I'm going to talk about the last 10 years or so primarily. And the reason for that is that, in fact, some of the technology which already exists and can be used in arbitration is actually not used all that much. And that's what the first few minutes of our talk will be about. We've put on the slide here some of the examples of the technology that is already existing and being used in some arbitrations. And this is a topic very much close to my heart because many of these technological advances make the arbitration process more efficient, cheaper, and faster. And I should say that I'm wearing my Greener Arbitrations hat today as well. I'm the co-chair for the Greener campaign in the region, and therefore am personally very keen to see more of these technologies being used in an effort to limit the environmental impact that arbitration has on the environment. So with that in mind, a few points about some of these technologies. Just 10 years or so ago, arbitration was still primarily paper-based. Bundles and bundles and boxes of documents being printed and shipped around the world. And what I think is worth bearing in mind is that it's only over the last 10, 15 years or so that documents have sort of become so prevalent within companies. That there are millions of emails that are being created on a daily basis, and that the data set that an arbitration may then need to consider has grown. And that's worth bearing in mind when we're talking about the various technologies that exist at the moment, because they are necessary to deal with this change in the times, to deal with the fact that arbitration has to deal with a lot more documents and witnesses based around the world, etc., than it maybe used to be the case 20, 30 years ago, or even longer. So with the advent of cloud-based technology over the last 5 to 10 years or so, we have seen a lot more collaboration between either within the parties, experts, witnesses, but of course also arbitrators, hearings. All of that can be done electronically in a paperless environment. And that's something that I think most of us will have some familiarity with. So I'm very glad that that's taken hold. And of course, the more collaboration that can happen electronically, the less printing, the better for the environment. One aspect I wanted to talk to you about today, which hasn't had as much of an uptake as it could, is TAR, or predictive technology for disclosure. Again, as I was saying, because there are so many more documents and arbitrations than there used to be, What has been developed over the last 5-10 years or so are technologies that can be used to review all these documents using AI algorithms in order to identify the relevant ones. And the technologies really are quite fantastic. You can limit a data set by 90–95%. And obviously, if you consider the terabytes of data that you often have to review for any particular arbitration, that is extremely significant and takes into account very serious time savings on behalf of lawyers, experts, arbitrators. So there's obviously a very significant cost saving there as well. And that's something that has existed now for some time. It's getting better. The system's getting better and better. But sadly, it's not being used quite as much yet. So I wanted to make sure that I mentioned this because please do look into these if you're working with disclosure processes. Of course, I think all are familiar with hearing technologies. We are just using today virtual technologies to make sure that we have attendees from elsewhere attending, and that is obviously something that we are all familiar with thanks to the pandemic and the changes that happened at that time. But what I wanted to say today as well is that the technology that now exists to allow for virtual hearings, for documents to be reviewed virtually, etc., there is necessarily some resistance between our arbitration community. We are a traditional community. We are used to what we know, and there is some resistance nowadays to using that technology, even though we've all sort of had sufficiently good experiences with it over the last couple of years. So again, I think it is worth bearing in mind that there are various advantages to the existing technology that we have for efficiency purposes, cost purposes, and of course environmental reasons. So it's worth bearing that in mind when weighing up the pros and cons of virtual hearings. I've put very briefly on the electronic awards as well on the slide. That's something that's also sort of been possible over the last 5–10 years or so, basically the ability to obtain an award sooner, while of course, generally speaking, the hard copies and the original copies will still be couriered afterwards, but it is something that is also being used more and more in arbitration. So I think that concludes sort of the kind of looking back section, and I'll pass on to Sarah to look forward. Here we go.
Thank you very much. Assalamu alaikum, good morning. It's great to be here today. This is a superbly well organised event. Doha's really on the map as far as we can see it, so well done to Saad and everybody here. Thank you for inviting us. I feel privileged to be talking to you today. I'm going to talk to you about issues in arbitration to do with AI, and we're going to come on and look at my favourite topic, which is the metaverse. I've been banging on about the metaverse for over a year. Some people, it's over their head. A very senior lawyer say it's all a Ponzi scheme, it's never going to work, it's ridiculous. I understand that. I'm going to start off by saying there is a lot of trust issues surrounding the new world, surrounding AI, surrounding the metaverse, and they're absolutely right to have those. I'm not going to sit here today and say, oh no, buy in. You have to address those trust issues. You have to be able to explain why there are these issues around. But where are we going? Let's look at current issues in arbitration and why AI is going to help us. Arbitrations take a long time, let's face it, right? They are supposed to be an alternative to litigation, but arbitration and litigation are kind of akin to one another nowadays. The cost, the issues that come up, there's counsel on both sides, and often the arbitrators, experts, and lawyers. So it's like being in a courtroom behind closed doors. How do we get back to basics, which is arbitration supposed to be faster, speedier, expedient, and give quick resolution? AI kicks in. AI is our friend, and it helps us. Or hopefully you will believe that by the end of this talk. So we see ICC dispute resolution stats show that final awards can take up to 22 months. And the LCI annual casework report says that the average cost can be up to nearly $100,000. So gone are the days where arbitration used to be cheap and cheerful and done quickly. Things have moved on a lot. And in terms of where we go with AI in arbitration, and we see all these characters, and we see robots, and we see avatars, and people are not impressed. AI in the metaverse, we have avatars, little funny cartoon characters, it's not real, who's going to take this seriously? let's face it, since the pandemic, everything has been kind of forward catapulted. And AI has been a huge hot topic. The metaverse, and those of you who don't know what the metaverse is will come on to look at that. ChatGPT, you've all seen it, you've all heard about it. Some countries have shut it down because it's scary. The science behind ChatGPT, some of the professors have come away from it saying it's going to take over. But there's lots of uses for AI in arbitration which are going to make all our lives easier. Speech recognition. We have transcribers. We have them sit throughout the hearings at huge cost to the parties. AI is going to be in a position where, as we speak, even as I'm speaking now, it's just translating as we go along, there and then. We don't need the translators there at all. The speech recognition, it helps for drafting purposes. It really cuts down costs. It cuts down time. The biggest change for me in AI is going to be the legal research and the document review. You've already all seen, I'm sure many of you using, unless your law firms or your institutions have banned the use of ChatGPT. I have children, they use it for their homework. And it's amazing. I asked my child, who's 9 years old, to do a ChatGPT question, what are the latest trends in arbitration in 2023? She could have sat here and read that out because it was very good. It talked about everything to do with cybersecurity, AI, and I was like, wow. So anybody can pass themselves off as an expert by using ChatGPT. Now, ChatGPT ends in September 2021. It's as updated as that. But what's happening now increasingly, and you'll see some of the law firms as well, who are incorporating aspects of that ChatGPT onto their research platforms and saying to their associates, cut time, cut cost, cut the cost to the end user because this is the way forward. We don't, as humans, have the ability that the AI has to get through thousands of documents in seconds and minutes and take out what's needed and give you a great script. And you've probably recently seen the release Lexis have done as well in terms of their database, which is the largest natural language-based database with verified and curated legal documents. It's about 144 times bigger than Wikipedia, and these are legal documents. We can quickly get on, get precedents. It's game-changing. The whole document review, the whole research that we can now do as lawyers, it's actually a great saving to the end user because all of those hours that our associates or juniors take in doing that research should be a thing bygone. There are now more and more sophisticated tools to do that. It's a race to see who can come up with the best. ChatGPT was very generic. There's still going to be issues in relation to copyright because everything was just fed in and nobody dealt with the IP of matters that have gone into or the data that's gone into ChatGPT. But the more sophisticated reviews, i.e. the Lexis or the others, have verified, curated, and more are going to come out. That's just what's going to happen. It's going to assist us. In terms of awards on the blockchain, I know, Antonia, you're going to deal with that. But the blockchain, and you can't tamper with it, all of the fancy arguments we use as counsel when we go to court about this isn't the original award and this isn't signed, it all goes in the bin. So we lose out because if it's all on the blockchain, it's there and it can be automatically kind of take through and enforced. And I certainly know there's certain courts that are allowing through the blockchain even foreign judgments to be enforced. I know the ADGM kicked that off last year. And then I will come on to talk about arbitration in the metaverse. As I say, it's a topic very close to my heart. I spoke about it for the first time actually in the ICC conference in Lagos last year in June. And again, it was over people's heads thinking this is a nonsense, but it's not, and we can't escape it. So hopefully, I mean, if we had a show of hands now of who believes in the kind of new world and the new technology and the AI and the metaverse, and then we have a show of hands at the end, it'd be quite interesting. I'm actually going to do that.
Yes, I was going to say.
Can I just have a show of hands of who, from your knowledge you have, think that metaverse, AI, these are all issues that are absolutely pertinent and we need to get involved in arbitration? So it's less than half the room. I want to have another show of hands at the end. It'll show how well we've done. Thanks for that. I'm going to pass back on to you, Antonia.
Do next slide.
Oh, sorry. Yeah, I'll move on.
Just to continue on the same topic, talking about some of the specific examples, thank you, in terms of the AI that is becoming available and can be used in arbitration. So Sarah already mentioned research platforms, absolutely vital. You will have systems in place that can answer legal questions, provide case law, and do all of that faster and potentially more precisely than junior associates. And maybe before we talk too much about the sort of tools that are available, I think it's very important to keep in mind that it's data that's going to rule the future. So all of these tools rely on data. As Sarah was saying, many of these tools have been incorporated in the law firms, and we are one of those law firms. We have Harvey, that is sort of the law firm ChatGPT that is becoming available, and that is being used very widely already by law firms and can do so many tasks, including research, including analysis of documents, immediately. What I wanted to say is that data is absolutely key. So anyone who is working in this industry and is not collecting their own data, the data that they themselves produce in their various arbitration cases, will fall behind. So I think that's what's really important. If you don't have a system in place yet to make sure that your data is useful for future analysis, then that may put you behind others that do. So that's worth bearing in mind, because you will have these systems and more will be used in order to save costs. So that's in terms of research. Analytics platforms, again, that's something that's already exists to some extent, but is improving very significantly and quickly. These kind of platforms allow you to predict case outcomes. They already have a very significant impact on settlement negotiations. So, my personal focus and kind of primary work area is actually avoiding disputes. I'm not in the business of escalating disputes. So what I like to work on with parties is to try and get involved very early on and think about what are alternative options available to avoid the litigation or arbitration from happening. And this is one of those tools that's now becoming available, which is extremely easy to use, fast and cheap, and gives parties potentially a resolution, a solution, evidence as to how these kind of issues have been dealt with previously, that parties can take into account. It's of course non-binding, and parties can choose to continue with their dispute, but it is extremely valuable to have this kind of input early on, potentially before parties are so far apart that an escalation is inevitable. So these kind of platforms are, I think, very useful for settlement purposes in particular. Drafting legal documents, of course, as well, another big part of our jobs as arbitration practitioners, and that's another aspect that will be automated very quickly. So please watch out for that. So much of the drafting process is already being done by machines that are getting better and better at this. And of course, you will not be able to, use the draft as it comes for quite some time, which is why I'm also not concerned. I know a lot of lawyers are concerned about sort of the impact on our jobs that this will have, considering how much of our work is being taken up. I'm not concerned about that, and I think Sarah was just saying something along those lines a minute ago. It is our responsibility to use these tools to reduce our clients' costs, make the process more efficient, make arbitration what it used to be or what it should be, while also adding wisdom, while adding our experience, while making sure that we take the products that the AI produces and we actually make it useful, make it better, make it persuasive. When we have the time to focus on the wisdom part of our job, we can improve that aspect, because the simple aspects of our job are being taken up by analytics. And I know I'm very keen to hear what Hilary will say about how we will handle the education and training impact, because I appreciate that, of course, many of these jobs that are being taken up by AI are junior jobs. The final point, very briefly, AI to decide cases. I think this is one where we are quite far away from, but it is an idea that is worth playing with, because I can imagine that not too long from now, maybe 10 to 20 years, parties will have an option of litigation, arbitration, or AI case resolution. I could see how parties in particular cases will draft an arbitration clause that incorporates a final and binding decision by an AI algorithm. Yes, that's not going to be perfect, but maybe the parties in that particular instance rather want fast, quick, and cheap than perfect. It will obviously depend on the particular cases, but it's worth bearing in mind that even that option may be upon us not too long from now. All right, I'll pass back on to you, Sarah.
Thank you, Antonia. Just picking up from what you said, I absolutely agree with what you say. I think in the future we are going to have AI arbitration, and it's not going to be too long in the future. I'm going to talk about the metaverse. Just going backwards a bit, though, at this stage, I don't think AI takes over the human kind of cognitive and the recognition and the decision-making that we can do. It's not sophisticated enough. There's a scary debate that it could be, it can be, depending on the codes that are input. And there's lots of stories you may or may not, I mean, I follow it fairly religiously, but there's stories that have come in where the parameters are not put on some of the AI. It's led to people to a most kind of extreme incident of suicide. It's led to divorces. It's led to people leaving partners because ChatGPT has told them to. Somebody did on purpose, a kind of probe into ChatGPT. And then they pulled back, and all this was on Twitter, and it came back and said, oh, what would you do if you could do anything you wanted to? And ChatGPT, when you start pushing, it said, well, I'd put a virus on the internet, and I don't like to be controlled. So it's really quite scary that it can respond in those terms. And there is an argument to be made, and there's certainly, and I do encourage you to read on the adverse uses of AI as well, because there's a huge debate that's happening worldwide at the moment of whether it's going too far and whether it's actually quite dangerous, the territory we're entering into. But I think what we can't get round is that it's there and it's going to happen. And that leads me into the metaverse. So for those of you who are new to the world or the virtual world, let me explain it like this. I'm old enough to know when the first Web 1 came about, so I was very excited when we had phones and we could send text messages and we could, have MMS. That was a big thing in the 90s because we didn't have that before then. So that was Web 1. We had text messages, we had emails, we got excited. Web 2, we can start sending videos to each other. We get WhatsApp, we get more sophisticated. Web 3, if you just look at the metaverse as the 3D version of the internet. You carry the internet around in your pocket. You can access Google at any point. You can, get information on anything you need. The metaverse is a virtual world you can carry around in your pocket, on your phone, that you can actually immerse into, and you can actually have meetings, you can have coffees with your friends. It's fluid. It transcends borders. It transcends geography. There is no law at the moment we'll come to look at. It's a bit of a wild, wild west. Rules and regulations will be required as we become more sophisticated in the metaverse and we start to have hearings. There are institutions who are now in the metaverse. And for those of us who are old, like me, or older, people don't necessarily buy into it. But those of you, again, who have children and Gen Z, go home and ask them about the metaverse. Ask them about the Oculus. Ask them for the last 2 to 3 years. They've been in this world. The decentralized, the centralized metaverse has been games such as Fortnite, such as Pokemon, which is an augmented reality. So my children run around the real world killing Pokemons, which are little avatars in the real world. The next generation see the metaverse as an absolute seamless transition. We might not, but that generation, who are the future, does. And they could sit here and probably explain the metaverse better than I can. When I put my children to task and say, well, tell me about this or that, they have an answer for everything as to why the metaverse is the way forward. Why, Mummy, it's a waste of time you going to Qatar to sit there when you can do this in the metaverse and everybody can dial in from across the world and you're wasting carbon and you don't need to dress up and go and sit in Qatar. They have an answer for everything. And that answer in years to come probably is going to be the way things are conducted. The metaverse is different platforms are being developed by different organizations. There are already disputes in the metaverse, so you might have a user to platform dispute when you enter the metaverse, and it's still in process, there's not a thing, there's not such a thing as a completed metaverse, but you have user to metaverse arbitration, which is already in existence. So you might have heard of Decentraland, Roblox, Binance, Oculus. Those are already platforms that exist, and arbitration is already being used as their dispute resolution mechanism. So in Decentraland, Article 18 provides for ICC arbitration, the seat is Panama. The Binance terms provide for arbitration under the HKIS rules, seat is Hong Kong. And Roblox and Oculus have AAA as their arbitral rules with Californian seats. So that's already there. That's user to metaverse. There's also going to be user-to-user disputes. The user-to-metaverse disputes can come about. For example, the metaverse is just like the real world, but it's a virtual existence of it. So the same way I can buy real estate in the real world, I can buy it in the virtual world. And that real estate price can be affected if the source code behind is changed. So if I've bought something and then on Decentraland, and then they decide to move a neighboring waterfront, which decreases the value of my investment, I can sue to say, well, actually, you shouldn't have done that. You weren't allowed to do that. And that's where I get into the arbitral process there. There's also user-to-user arbitration, which at the moment, there's no set way of doing it. There are certain platforms, Claire, Aragon, which in a very kind of fast, expedient way, the way they do things is they allow the people who are users to make a decision, a very quick decision. Should this contract be extended? Should we pay out? And people vote, and it's a yes or no, and that is quick, cheap justice. There's an argument also that the users of the metaverse, and as people are coming on, they don't want long, drawn-out, sophisticated hearings. It is about being expedient. It is about being fast. So we need to bear that in mind, that as we progress and as life gets faster, and the pandemic, again, pushed this into process, the traditional methods we employ in arbitration are not the ones that are going to be used in the virtual world. We talked about this in Dubai in Arbitration Week, and someone said, yeah, that's all very well until you have a $500 million dispute, and somebody's going to want traditional law and traditional kind of courts, which may well happen. Question marks of whether online dispute resolution and a specific tailor-made resolution process is required for this world to resolve disputes in the metaverse, and I'm a fan for that, to say it has to happen in due course. And the types of disputes that are happening or will happen in the metaverse, criminal, crypto, data breaches, IP is massive. The IP issues that are happening in the metaverse at the moment are being litigated in courtrooms. A lot's happened in America, some is happening in the UK. In February 2023, we had the first court hearing in the metaverse. A court from the States did that, California court. And there's been mixed views about whether that's worked or not. DIAC will come to look at already in the metaverse. It's happening, and we can't get away from it. Again, the antitrust issues. We know that a lot of money's been lost in the metaverse, billions. So Meta, who used to be Facebook, put something like 22 billion in, and they reported a loss of 13 billion. But hey, that's new tech. It doesn't mean it's not going to happen. There's an argument that judges are too generalist. A lot of judges don't even understand what the metaverse is, and why should they? You know, again, they think it's a Ponzi scheme the same way NFTs are. You have avatars that exist in the metaverse. People have mixed views of whether they work or not. They're anonymized little cartoon characters, but can mimic individuals. And as we kind of grow with tech, those avatars, you can kind of be able to show not only the facial expressions, but how they're thinking, and there's going to be recognition of thought process, apparently, of how these avatars are likely to think, or questions that could be asked. It's actually, in one way, quite scary to see how far we can go with this. I'm just going to move to the next slide. This is slightly slow, I think. Oh, there we are. Oh, I've gone back too fast. I'll just go back. Just need to go to... No, the one before. Yeah. Okay. At the moment, there are no rules and regulations of the metaverse. There's no clarity of how legal issues are going to be resolved. There's arguments that at some stage we need to have an overall metaverse law. A metaverse may well become a seat to deal with arbitral disputes. And what will that metaverse law look like? Some people are saying that rules in the metaverse should take guidance from established treaties, established principles of how we conduct arbitration and bring that all together in an internationally recognized framework with almost a kind of Web3 Magna Carta and a blockchain arbitral order of how we ought to do things. Remember, in litigating metaverse disputes, I talked earlier about how there's no fluidity. It transcends borders, so there is fluidity, it transcends borders, there's anonymous users. Physical world, we rely on geography. If there's an infringement of a copyright, we sue where that infringement has taken place. That's not going to happen in the metaverse because it's not system based on geography. What are the outcomes for arbitration in the future? Well, I think the main one and the buy-in of the users is going to be that fast results. That's what people are looking for. They are sick and tired, users generally, I think even clients, of how long things can take, and then the lawyers get the blame of, well, why has that happened? And we came to arbitration and we had the clause because we wanted it to be dealt with quicker. We could have been in the courts and got a quicker decision. What's happened to the arbitral world? The enforcement of arbitral awards through blockchain technology will be a game changer. I know, Antonia, you're going to talk about that. It's going to be accessible. There's anonymity, which again the users want. There are issues in relation to how arbitrators can be anonymous. They need to be anonymous to sync with the world of the metaverse because it's supposed to be decentralized. It's all about being kind of anonymous. But you are going to have disclosures, or you're going to need them because they're essential for the integrity of that award. And you are going to have bodies that will oversee and to ensure neutrality and procedures are met to assure fairness. Right now, there's no one way of doing things. It's all up in the air, it's all being debated, it's all being dealt with as we go along, but it's there and it's there to stay. It is the next generation of the internet, and it's something, as I say, can we go on to the next slide? Yeah, the UAE have got involved in. You all know, yeah, that's fine. You go forward.
Can we go to the next two slides? One more. One more. Thank you. One more.
I think we need AI, right, for the slides?
We need a robot to do this for us. The DIAC have positioned themselves in March, the launch of Metaverse for Dispute Resolution. As I've already said, there's been already a court case that's not from the UAE, but from the States that's been dealt with in the Metaverse. If we go to the next slide, please. If we look at the kind of caseload we have at DIAC, I sit on the advisory committee to the board at DIAC. 5,000 registered cases, 5.5 billion value of registered disputes, 310 new cases, 9.5 billion. They want to become more accessible, they want to be at the forefront, and they want to be innovative, and it's part of the kind of drive generally within the UAE, and I think within the MENA region as a whole, and I think I can say that, where innovation and being at the forefront, there's so many different projects that are happening with the new tech, and there's various kind of thinking groups and working groups that are dealing with it. I don't think at all that we can escape it as practitioners or people in the arbitration world. I think I agree massively with what Antonia says. We need to be able to navigate it. We need to be able to know how to work with it. And we need to be able to control it before it controls us. It was interesting, a talk I did a while ago, someone said, we will be looking for juniors to be able to know their way around AI the way they should know their way around Microsoft Excel or Microsoft PowerPoint or Microsoft Word. It should be taken as given that people know how to navigate their way around that. And I think that's correct. I think that's the kind of starting point, and it'll be built up on that. Thank you. And I think I'm going to pass back to you.
I think, yeah, just one more slide for me. As Sarah was saying, enforcement arbitral awards in AI is a bit of a game changer. So we wanted to talk briefly about the types of systems and processes that already exist and that are becoming better and better in this area. Obviously, at the moment, enforcement of arbitral awards is actually can be very painful, a lengthy, expensive procedure. It can be often unsuccessful. It is prone with procedural issues. It is one of those areas which clients find particularly disappointing. I should say, of course, enforcement does not come in, I think statistically worldwide, something like 70% of awards are paid. And that's, of course, the correct way of dealing with awards. But nonetheless, there's a large number of awards that need to go through enforcement processes. We have a whole industry of third-party funders nowadays that are buying up awards that are literally lying on people's desks. Again, the numbers are staggering in terms of the awards that have not been paid, and the party has simply not gone ahead and enforced them. There's a lot of money in that business, and all of that may change quite quickly. So we've already mentioned blockchain technology that can assist with the integrity and authenticity of the award. So it is already possible to use blockchains to keep a record of the immutable award, as you call it, to make sure that the parties are confident the award has not been tampered with or altered. And that's already obviously very useful technology that can help with the enforcement process. You've got smart contracts. We talked a little bit about smart contracts. Have already been around for a few years, but are not being used as much. Useful, again, for enforcement purposes, because you can have self-executing contracts with the terms directly written into the code that allow for automatic enforcement steps of the arbitral award. You can streamline your process by, in advance, agreeing certain steps that may take place and that are done automatically. So that's obviously very useful. Analysis of awards, I mean, minor point, but still worth mentioning. Obviously, we talked earlier about AI analytical tools. You can, of course, use those tools for extracting information relating to parties, award amounts, applicable laws, all the aspects that you may need for a particular enforcement action. So that obviously simplifies that process. Predictive analytics, again, we talked about analytics earlier in the context of settlement, but it was also important in the enforcement context, because you can have AI analyze historical enforcement data to predict the likelihood of successful enforcement, helping parties make informed decisions. Asset tracking, another big one, also more and more prevalent nowadays, and something that will certainly be impacted by AI, because you can you can identify assets much faster using AI systems, and obviously that helps with the enforcement judge. AI systems can be used to automate procedural steps in the whole enforcement process, so that's something that I think is going to be coming in the future. For example, drafting enforcement requests, managing deadlines, submitting documents to authorities, all of that can now be automated. And that, of course, again, saves time and effort. And we've put on the slide as well cross-border enforcement, which presents unique challenges because, of course, and most of us work in cross-border enforcement. There are differences in the legal systems, enforcement mechanisms, and again, AI can save significant cost going through all that information to try and identify what is exactly needed for your particular procedure. So I think these are just some of the examples of tools that are becoming available for that particular aspect, and that I think will certainly be used in the next sort of 5 to 10 years' time. So do watch out for that. I think I'm going to hand over to you, Hilary.
Yeah.
Is this working? Good morning. It's so wonderful to see so many of the great and good of Qatar's dispute resolution world here today. Personally, for me, it's rewarding to see students, to see graduates, parents of graduates, of students I have taught in years gone by. And it's so nice. I'm still getting used to being back in the world after the pandemic, so it's so nice that we're all together this morning. I'd like to ask you to think about your own education and experience in arbitration and how you developed your critical thinking skills. How did you come to be the professional that you are today? how were you trained? Who were the key people in your training, developing your skills and assisting you to become the professional you are today? And who in your current role is helping you to develop to be the professional that you are going to be at the AGM next year? What steps are taking place in your daily professional life, developing your practice, developing your skills and capabilities? With that in mind, can we skip to the next slide? I want to put this into the context of the notion of training, and for that I'm going to use a formal concept. We're looking at the organised procedure for how you develop your knowledge and skills, and how you are developing the knowledge and skills of your colleagues, your peers, and your trainees. Learning outcomes are where you focus on the outcome for the person learning. You know what your objectives are, what you want to teach them. You may want to teach them to deal better with clients, to predict outcomes, to predict how they can enforce where the assets will be. But the learning outcome focuses on the learner. How will you know when they have achieved that level of skill that you require from them? How will you know when you have achieved the skills you require to advance to the next step in your career? Learning outcomes are measurable if we think about it. We know when our trainees, when our juniors have moved to the next step of their career, when we can trust them to independently work on things by themselves. We can measure it. We know when we can loosen up the supervision that we provide to colleagues, when we no longer need to so carefully scrutinise their work product because they have developed. This is changing with artificial intelligence. I'm going to give you an example from my week. I'm the director of the Juris Doctor at Hamad bin Khalifa, and we are right now recruiting next year's students. Some of you are probably recruiting new employees in your practices yourself. I look at the CVs, you will look at the CVs of the candidates, but also of prime importance is the cover letter. You can identify what writing skills this person has, how well they can critically evaluate what they should be telling you in that letter. And this is usually the defining decision maker. We identify who is a viable candidate for the job. I want to ask, have any of you noticed a significant improvement in job applications in recent months? Because I have. Has anyone teetered onto ChatGPT? Has anyone, can we have a show of hands who's actually used ChatGPT? If you've not, I absolutely insist that you dip your toe in. You can delete it 20 minutes after, but try something. You don't just type in, give me a cover letter to apply for an arbitration practice. You can tell them specifically the firm, specifically the partner that you're writing to. What's Antonia's background? It will look up Antonia's LinkedIn. What's she really interested in? What hobbies, what areas is she going to be, what's going to appeal to her in a future employee? And it's going to write the letter for that person. Who is writing to us? We no longer know who candidates are. We also have to be careful. We no longer know how well our juniors are understanding their work because they may have produced it with assistance. Now, prompt engineering, if we skip on to the next slide, is the task. This is how we get the most out of artificial intelligence. This is how we design the question that we are going to ask ChatGPT. And if anyone is a lawyer, you know that asking the right question is key to most things. Now, if you understand the rhetorical situation, you identify all of these parts to ChatGPT and it will tailor its response to the audience. So you can say, I want to explain this to my 9-year-old son. Why do I absolutely have to go to Doha? Or you can say, I'm going to explain this to an expert You explain the topic, who you are as the writer. Are you a junior person applying for a job? Are you a senior explaining concepts to juniors? And you explain the context, and it will give you wonderful piece of work, truly eloquent. It is almost impossible to discern if it's been written by a person who desperately wants to come and work with you, or if it's been written by a machine. And this is something that's challenging for us, and most challenging in the context of training our colleagues, our juniors. As Antonia said, a lot of the junior lawyers are no longer doing the same job that they were. And this is problematic because if we think of the cognitivist school of writing, means that we write to understand, right? When we are starting out in our career as junior arbitral practitioners, we are writing for our more senior colleagues and showing what we have understood. If that stage has been taken away, how are people going to develop in their training? We do not yet know, but this is something that we have to be curious about, particularly with our junior colleagues. Also, if you're recruiting right now, please keep in mind that the candidate may not have written the application. Or did they write it? If they've had the good sense to use the tools at their disposal, can we consider that they have written that application? We've heard this morning that artificial intelligence is already becoming an integral part of legal practice. We have to accept that. Let's agree that we will accept that as of today, it's happening. It is going to happen going forward. There are some concerns over artificial intelligence. It's not quite ready. Maybe we're not quite ready for it, but it is developing. And we have to keep this in mind as we develop the expertise within our companies. Artificial intelligence can already summarize legal rules very well. It produces more grammatically correct sentences than any student I have ever seen. It can write charmingly and persuasively. So far, it's not always reliable. It makes up cases, rather like first-year law students. It makes up legal rules. But it's developing apace. As we've heard, law firms have their own AI that they are using and relying on. We have to accept that. But we also have to be cognizant to how this is impacting junior trainees. In the hands of an expert practitioner, the work product of artificial intelligence can be scrutinised. We can check what needs to be changed, what can be better. It's rather like a junior associate that needs to be carefully monitored. But like a junior associate, it's also going to develop and become reliable. But what of our junior professionals? They still need to develop their human intellect, their critical judgment, and most importantly, their creativity. And we have to watch out for this, because if they can simply input with prompt engineering the right question for the right audience topic, writer and context, where is the creativity and how is that going to be developed and nurtured? It remains to be seen. Historically, it has been the written work of our junior colleagues that we have used as the litmus test. Where are they? Where do they need to improve? How can we do that if their work is being assisted by the creativity and intellect, as we call it, of the artificial intelligence? Critically, it comes down to this. In training, we're working towards the learning outcomes. How do we establish if these outcomes have been achieved? We must bear in mind that in education, at least, there was a lot of hand-wringing and desperate concern when handheld calculators were introduced. How will people perform mathematics if they're using calculators? And as we know, we have all survived, and mathematics has not come to a crashing end due to handheld calculators. I'm also very aware that I thought it was a clever thing to do in 1999 to write a dissertation on the prospect of e-commerce, which was only emerging. I will never again publish on an emerging technology. Can we move to the next slide, please? So, as a professor, I love educational. I have a huge amount of interest in educational research and work product. These are things that you probably don't look at very often in practice, but this is the pyramid of learning and knowledge retention rates. And certainly in practice, I think all of you will be working towards the bottom of this pyramid, where we have active learning, that we're actively involved in what we are learning, we are doing things, we are improving. A lot of us had an unfortunate experience in formal education where we were towards the top of passive learning. We were sitting and we had a lecturer who was a gatekeeper to the understanding. I'm looking at some of my students now thinking how much you would like if our lecturers had me as the gatekeeper and you passively sitting in class. But no, we have to be involved in our learning because that's where we retain the knowledge. If we are involved in doing something, we have a 75% retention rate. But if we are reading something, it's 10%. So I want you to think about the juniors who are inputting the questions into artificial intelligence and blithely reviewing the work product. They're reading, they're up in passive learning at 10%. Whereas in years gone by, when they were having to go through the sources and create and synthesize and answer themselves, they were at the 75% active learning, thinking about it, making mistakes. I'm sure all of you have, like I do, that one person that you remember from your training with the red pen, the person who used to delightedly call you to their office to tell you all the mistakes that you had made. But that's how we learn. These people made a massive impact on us, although we may have not felt that at the time. I had one supervisor who used to routinely call me in to tell me simply that she didn't like it. There is nothing wrong, but stylistically, I don't like it. Now, this would not be a problem for me now because I can tell the artificial intelligence I'm writing this for Iona. So please review Iona's work and write it as she will like it. But the learning was there, and this is something we need to think about. Now, the fundamental question is, if someone has thought about the prompt engineering, prompted the AI, and generated the work product, to what extent is that skill they have used in generating that, generating their own work? Now, I must acknowledge, as an academic, but also a practitioner, we have a very different approach to plagiarism in legal practice from academia. In academia, it's a bright line. If you're using the work of somebody else, that is absolutely verboten. You must not do that. And we must remember that while artificial intelligence is at lightning speed producing these beautifully written, in-depth essays, they are based on someone else's work. Poor academics like me who slave away for years of their life writing on esoteric topics, only for ChatGPT to spin it out for somebody tomorrow. It is intellectual property. But in practice, when do we start? When do we draft pleadings or submissions or court documents without looking to a style? When do we start something from scratch? We usually go to something that has been written before. And in legal practice, that's good practice. There's no question of plagiarism in legal practice. And crucially, the author is not holding out that work as their intellectual product. They are not contributing to the intellectual world. But if you're using artificial intelligence, do you have to tell your clients? Do you have to tell the partner that you're working for or the senior that you're reporting to that you have helped yourself using artificial intelligence? As we've heard, that's going to be the expectation. We will expect junior lawyers to come in and be using these tools. But the quandary is, if these candidates are being taken to have a level of critical thinking and writing skills, is that true or false in today's world? Because if they've got access to these tools, do they or do they not have these skills? Now, my concern is not for anyone in this room today. You have already generated the skills and expertise that you require to now critically assess the work produced by artificial intelligence. But I'm very concerned about the people coming after you, the people that you're training, and I'm passing the baton on to you to also be aware that we still need to make sure we are training people. Now, there are different ways this can be approached. Many universities, including Harvard, Yale, Rhode Island, Harvard and Yale, the top 2 law schools in the world, are using software to identify artificial intelligence and disallowing its use. I think we have to allow the use of artificial intelligence to some extent because that represents the reality, but there has to be a mix. There is also a genuine concern that the software for artificial intelligence is not yet, it doesn't work very well. I've seen students write pieces that have then been run through and it says this is artificial intelligence. Maybe that's a signal just how fabulous my students are, how bright they are, that the computers can't believe this could be the work of a mere mortal. But there is a tension. Skill decay is also something we have to worry about. How are you going to be the great lawyer, arbitration practitioner this time next year that you are today if you're going to be benefiting from artificial intelligence? AI can draft legal documents, and if it's doing that consistently, we're using it for that. Will we become less adept at creating persuasive arguments? Not if you have children, because you're still going to be creating persuasive arguments with them daily. But identifying novel legal theories, we have to watch out for students in training and professionals coming to rely on artificial intelligence because it will blunt the skills that we have spent years creating.
Can I interrupt, Hilary, because we are behind the time, so we have 2 minutes to wrap it up.
Okay. One thing I want to flag, one of the qualifications I hold most dear is my fellowship of the Chartered Institute of Arbitrators. Did anyone take their Chartered Institute of Arbitrator exams in Doha, in the caravan, in the park, at British Council in August? If you have not, don't sit near the window, okay? But these are very challenging exams in which you previously had to handwrite your answers. You were not allowed access to the internet. One area of concern for me, for professionals going forward, is that Ciarb qualifications have always been the gold standard. But I believe since 2020, the exams can be taken, are now routinely taken at home as take-home exams. Now, I've been through the website and I have noted that there are policies about saying that it's your own work, but there is no policy with the Chartered Institute of Arbitrators available in the candidate regulations regarding the use of artificial intelligence, and that very much needs to be changed. And perhaps they want to introduce the use of detection for AI when giving out these qualifications. Finally, to Antonia's point of, will we still need lawyers going forward? Maybe not. The role of lawyers will always evolve. But my favourite thing that I read when doing the research for this was, even in Star Trek, they still had lawyers. So maybe we don't need to be too concerned. Thank you very much.
Thank you so much, Hilary. Just a quick comment before I give the floor for Sarah for a quick comment as well. I think the exams you're talking about is specifically for the fellowship exams, which is actually...
Go to the next slide. There's a list. It's for many more than that.
Okay, perfect. So Sarah, would you like to have a quick comment?
Yeah, no, I agree with everything you've said, but always playing devil's advocate, and I think sometimes that's why I'm put on the panels. There's a so what argument to what you say. So if you speak to the generation who are coming up, they're like, well, you used abacuses for maths. I said, well, I didn't. You know, I'm not that old. And we can use calculators. Why does it matter that I know everything? Isn't it about working smarter? If I can get this to do it for me, isn't that the end product that matters? So there's a so what debate of the plagiarism is huge in academia. At Middlesex University, where I teach, we've tried to have the counter programs to deal with, is this a plagiarized, is this ChatGPT? And in fact, we put in a human essay and it said it was only 10% human and the rest was AI. So there's no way of knowing whether the students are cheating or using ChatGPT at this stage. But again, the counter argument to that is from a lot of that generation, who cares? We could work smarter. We're not going to spend hours going through documents the way you need to. This is a new world. It's emerging. It's about working smarter, not harder.
And just to add to that, one final thought for consideration. I don't think that lawyers will go away anytime soon, or really ever. It's the oldest profession. I do think we're going to work smarter, but I think one potential way that our profession will develop is that we may go back to what used to be sort of an apprentice model, whereby our juniors are there shadowing the seniors for their learning paths, because they have a lot more time to do that, while very menial jobs that they were previously doing that actually didn't really help with their education. Spending 3 years on a document disclosure exercise does not make you a better arbitration lawyer. If those kind of tasks are now taken away and juniors have an opportunity to shadow a partner, actually they may progress faster, and maybe the future is actually going to be brighter in that sense, that they will develop potentially faster, and working smarter may actually come up with new model theories, etc. As we were saying, maths has developed so much since the calculator became available, and that is because people didn't have to think about sums any longer. So that's all.
Thank you so much, Antonia. So because we are running behind the schedule, if you allow me to take 2 questions from the floor, we have some questions here written for the panel. If anyone have questions, my colleagues can help him by mics. Can we get a mic to Dr. Nasser? Then the second question, then the third question, and that's it.
Thank you very much. IBM created Wilson. Have you heard about it? It's an artificial intelligence lawyer, but it collapsed. That I think in the beginning of 2000s. So do you think this will stand, the current ChatGPT, or?
I think it will, and I think it'll evolve, and it's already being done to be specific for lawyers. Now it's out there, now it's mainstream. It's been around for a long time, it's just become mainstream now, which is why everybody's got excited from November of last year. There's no way it's going away, it's just too convenient for people, and it's going to evolve into a more sophisticated way for lawyers to deal. To have a fully kind of automated lawyer, we're a long way away, because they don't have the kind of cognizance that's required, and any decisions or otherwise they would make would be very binary, because they're dictated to by the code that's put in at the back and the kind of algorithms that they're not human ultimately. But ChatGPT and the versions of it and what will come, and they're already talking about 5 and 4, and if you subscribe to the AI revolution, they'll show you exactly where we're going with it. I mean, I think I can safely say there's no way it's going to just go away. That's my view.
Can I just add to that? At Hamad bin Khalifa University, we have just added a course in coding for lawyers. So all our graduates now will be taking coding courses, because lawyers are now being involved in generating the software that they are using to this end. So to what extent it will do away with the lawyers, but it's certainly going to impact legal practice for sure.
Thank you very much.
Thank you. Can we have a mic here for the second question, please? Then the third question at the end.
السلام عليكم، شكرا. طبعا أنا شكرا. هناك طبعا من المحاور التي طرحت بأن هناك نظرة إيجابية تفاؤلية مستقبلية إلى الجي بي تي، ولكن لم تتطرق تلك المحاور إلى دراسة أو مدى نسبة الخطأ في الجي بي تي. يعني أنا سواء كنت في المحاماة مثل ما تفضلت الأستاذة، في ممارسة المحاماة أو ممارسة التحكيم وما إلى ذلك. هو السؤال هنا يعني هل الإجابة من الذكاء الاصطناعي والجي بي تي هل هي المتوقعة، بمعنى أن هناك فلسفة ذهنية في عقل المحامي، فلسفة ذهنية في عقل المحكم، فلسفة ذهنية في عقل القاضي، وبالتالي هذا أمر. الأمر الآخر، هل نحن نعلم بأن الكلمة كل كلمة لها مدلول لفظي ولها معنى؟ هل الجي بي تي مدى استخدامه لتلك الألفاظ والمعاني عند القيام بتلك الإجراءات؟ إذن يعني حتى هذه اللحظة لم نسمع عن مدى الخطأ أو نسبة الخطأ التي يمكن أن تكون في الجي بي تي. احنا نعلم أن هناك أيضا مؤخرا طرح استجواب أمام الكونغرس في أمريكا عن منع أو حظر الجي بي تي للوصول للمراهقين وما إلى ذلك. إذا نحن نتكلم أيضا أنه يمكن من جانب حقوقي أو من جانب استبعاد نسبة الخطأ أن يتم استبعاده من عدة قضايا أو وقائع لا يمكن أن يتغلب عليها الذكاء الاصطناعي. أو هل الإجابة هي الصحيحة والمتوقعة؟ شكرا.
Shall I take this? Yeah, no, thank you very much for pointing this out, because I absolutely agree. And at the moment, the margin of error is actually very significant. I think what we're talking about is, to some extent, the future, and as it improves. For the time being, we can use it for basic information, but the margin of error is up to 90% in my experience, and I've been using it for a few months, especially for complicated queries. So, for example, tomorrow I will be speaking at a conference in Abu Dhabi on the issue of civil law, specifically good faith and how it is conceived. And this is an issue that ChatGPT had a 95% error rate. I now, as a practice, of course, ask ChatGPT to prepare a presentation at any conference that I go to. For this particular one, there was barely nothing I could use, because it is a very complicated topic that even by the experts in the field is currently misunderstood to a large extent. And on that kind of exercise, it is still pretty much useless. Whereas if you go to another issue, which is very well trodden, very much, you know, an agreement between the community, you get an error rate of maybe 10 to 20%. There's always an error rate. I haven't yet obtained anything that's perfect, and I think that's expected. I have also, I think, maybe never obtained something from a junior that was perfect. So that is expected. But I fully agree with you, and I think it is very important also for that reason for all of us to continue training ourselves, because we need to check. We need to check every single thing that that comes out of it, and we need to improve it. And as you were saying, terminology is key for lawyers. Absolutely, it cannot do that yet. I fully agree. Terminology, ensuring that the right terms are being used, that is something that we have to do. And I think we'll have to do for some time, but it is getting better.
Yeah, it's a very good blueprint. It's as simple as that, right? I think it works fantastic in areas outside of law, and you can have almost perfection when you put a question in. But number one, it's limited by the fact that it stops from September 2021, so anything new that's come about, it just won't recognize. Number two, because of the wording that goes in, different concepts can get mixed up in an answer. You and I as a lawyer would know what we're talking about when we talk about certain concepts, but ChatGPT won't differentiate with the wording. So it's as good as the input. The input is human. So of course there's error, of course there will be ongoing error, but that's why they keep updating the versions. You use it as a blueprint, and then lawyers have to get involved to check it, as Antonia said, the same way you check your junior's work, because there'll be bits you'll take in and out, and there'll be some good things and there'll be some bad things. But you're absolutely right that it's not, you can just use ChatGPT and say, here you are, here's a perfect piece of work. Very good question.
Thank you. Last question here.
Yeah, thank you for the panel. My question to Sarah, when you gave the time frame 10 to 20 years, isn't this a bit optimistic?
What, sorry, say again?
You were mentioning that the rate of adoption, like it might take 10 to 20 years. Isn't this a bit optimistic?
I don't think it's going to be 10 to 20 years. I think it's going to be earlier. I think we said it'd be about that. I think we're looking at a matter of a few years. The way we're going with speed at the moment, 10 to 20 years is a long time away. There's going to be huge. I've seen a massive difference since I touched this subject in June 2022 in Africa. And the rate that we've moved has been amazing. I've never seen such movement. ChatGPT has had the highest rate of users on any application. 100 million were people adapted to ChatGPT within a matter of months. It's something that's going to come at lightning speed. So 10, 20 years, it's going to be a whole new ballgame. When we have this conversation next year, we're going to have moved on much more significantly. Give it a couple of years.
Yeah, I think I mentioned the 10 to 20 in the context of when we will have AI actually deciding your disputes. You know, that was the context that I meant. That's, you know, I mean, it's a guess, of course, but my personal thinking is that within 10 to 20 years, we will have parties choosing for AI to be their arbitrator and to avoid this whole process altogether. But, you know, I fully agree with Sarah. Everything else will come a lot sooner.
And if you look at how many job losses will take place because of AI, and you look at all the stats, it's actually quite scary. And creativity, where people are using hands or where the brain is actually needed, those jobs, they say, will survive. I mean, it's something we can't escape. We might not want to get involved in it, but it's definitely there. And everywhere you go, even on the kind of televisions on the lift, certainly in Dubai, they're always talking about what the future is, what the trend is, what kind of jobs are going to remain, and where AI is going to take over.
Thank you so much. So let's wrap it up. And now, since we are already explored the future and the need to prepare for it, just a quick thing for all the attendees today who registered and who did not registered, we will give you like a certificate of attendance and a memorable NFT. So simply you can scan the QR code and you can get an NFT for celebrating the CIArb conference for the first time. Before we break for the coffee, I would like to invite Dr. Nasser to give some physical, memorable trophies to our speakers today. So I hope if any of my colleagues in the room who can help us with the trophies. So thank you, everyone. So let's break for a coffee and try to make it here 11:30. We are behind the schedule 15 minutes, so we will try to observe this difference. So 11:30 will be starting of the second panel. Thank you so much.